Hi, in today's session, we will talk about the provisions related to separation in Hindu Marriage Act 1955. In the overview of the Hindu Marriage Act, we had spoken about what all is included as a part of the Hindu Marriage Act. Today, specifically, we will be talking about the provision of separation, which includes judicial separation and includes divorce. Starting with the separation of judicial separation. Section 10 of the Hindu Marriage Act deals with the judicial separation. It provides that either party to the marriage may present a petition to district court praying for a decree for separation on any of the grounds specified in subsection 1 of section 13. And in the case of a wife, also on any of the grounds specified in section 2 of clause 2 of section 13. We will look at what are the common grounds for both male and female based on which judicial separation can be granted. And then there are additional grounds available only to wife under section 13 of clause 2 of the Hindu Marriage Act. Starting with the common grounds for both male and female, it starts with adultery. I mean, either of these spouse is being cheated upon by the other spouse. In case a husband or a wife knows that their respective spouse is married and that the other person is alive during this petition, then the grounds of judicial separation strengthens. Cruelty. Either of the spouse or both are cruel for one another. I mean, that's a common ground based on which the judicial separation can be sorted. Desertion. Either of the spouse, if not alive or is missing since 7 years and above, calls for a judicial separation. Unsound mind. Either of the spouse, if is of unsound mind, the other person can file for a judicial separation. Conversion. If either of the spouse is forcing the other to convert to his or her religion, can file for judicial separation. Then we have leprosy or venereal disease. These are specific diseases under which the provisions have been granted that either of these spouse can file for a judicial separation. Missing spouse is a spouse missing for the past 7 years or above and not contactable. And renunciation of the world by either of the spouse on religious or spiritual grounds is another one based on which the judicial separation can be granted. So these are common grounds which are available to both male and female based on which the judicial separation can be requested for. Then there are additional grounds available only to the wife, which is under section 13 clause 2. First is bigamy, and the second one is rape, sexual harassment, molestation, bestiality, or sodomy. I mean, those are specific ones which happen against women, and women can sort for judicial separation. Degree or award for maintenance or repudiation of the marriage. I mean, these are specific four common grounds based on which the wife has an additional a reason based on which they can file for a judicial separation. Effect of the judicial separation. I mean, judicial separation does not snap bond of marriage between the parties. However, it gives a legal license to the petitioner to live separate from the respondent, and the latter can no more insist that the former cohabit, and children may be decided by the court while deciding on a petition for judicial separation, and even earlier, whole the partition is pending for disposal. If the cohabitation has not been resumed for more than 1 year or more following judicial separation, it is a ground for divorce available to either of the parties. But the first step typically is the judicial separation before a person goes in for directly a divorce. The next section of this presentation is the divorce, which is defined under section 13. A marriage on a petition presented by either the husband or the wife be dissolved by a decree of divorce on the grounds which are mentioned below. Similar to judicial separation, there are common grounds for both male and female which apply to both. And then there are additional grounds which are available only to wife under Section 13, Clause 2. Starting with the common grounds which are applicable for both male and female. The first one is adultery, which is defined under Section 13(1)(i). The act of indulging in any kind of sexual relationship, including intercourse outside marriage, is termed as adultery. Adultery is counted as a criminal offense, and substantial proofs are required to establish it. An amendment to the law in 1976 states that one single act of adultery is enough for the petitioner to get a divorce. Cruelty, it is defined in Section 13(1)(a). A spouse can file a divorce case when he or she is subjected to any kind of mental and physical injury that causes danger to life, limb, and death. The intangible acts of cruelty through mental torture are not judged upon one single act, but series of incidents. Certain instances like the food being denied, continuous ill treatment, and abuses to acquire dowry, perverse sexual act, etc., are included under cruelty. Desertion is defined under Section 13(1)(b). If one of the spouses voluntarily abandons his or her partner for at least a period of 2 years, the abandoned spouse can file a divorce case on the ground of desertion. Unsound mind is defined under Section 13(1). Mental disorders can become a ground for filing a divorce if the spouse of the petitioner suffers from incurable mental disorder and insanity, and therefore cannot be expected from the couple to stay together. Conversion, defined in Section 13(1)(b). In case either of the two converts himself or herself into another religion, the other spouse may file a divorce case based on this ground. Leprosy, defined under Section 13(1)(4). In case of a virulent and incurable form of leprosy, a petition can be filed by the other spouse based on this ground. Venerable disease is defined under Section 1(5). If one of the spouses is suffering from a serious disease that is easily communicable, a divorce can be filed by the other spouse. The sexually transmitted disease like AIDS are accounted to be venerable diseases. Renunciation of world, Section 13(1)(6). A spouse is entitled to file a divorce if the other renounces all worldly affairs by embracing a religious or a spiritual order. Presumed death is defined under Section 13(1)(7). If a person is not seen or heard alive by those who are expected to be naturally heard of the other person for a continuous period of 7 years, the person is presumed to be dead. The other spouse should need to file a divorce if he or she is still interested in remarriage. Non-resumption of cohabitation after decree of judicial separation is under Section 1(a)(d). It becomes a ground for divorce if the couple fails to resume their cohabitation after the court has passed a decree of separation. Non-resumption of cohabitation under decree of judicial separation 1(a)(d), 1(a)(2). Failure in observing the restitution of conjugal rights for at least 2 years. So these are the common grounds for male and female both. Again, there are some specific additional grounds that are available only to wife under Section 13(2). The first one is bigamy, the other one is rape, sodomy, or bestiality. The third is degree or order awarding maintenance, and the last one is repudiation of the marriage. These are same as what were available in the case of judicial separation as well. A petition for dissolution of the marriage may be presented by both the parties to a marriage together on the ground that they have been living separately for a period of 1 year or more, and they have not been able to live together, and they have mutually agreed that the marriage should be dissolved. If the petition is not withdrawn within 18 months after the presentation of the petition, the court shall, on being satisfied after hearing the parties, pass a decree of divorce. Another part which is critical in case of divorce or the judicial separation is maintenance penalty. Maintenance penalty and expenses of the proceedings are a much talked about situation when there is a judicial separation happening or a divorce happening. Where in any proceedings under this act, it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the proceedings. It may, on the application of the wife or the husband, order the respondent to pay to the petitioner the expenses of the proceedings, and also monthly during the proceedings such sum as having regard to the petitioner's own income and the income of the respondent. It may seem to the court be reasonable. Now, this is making sure that the other person is well financially covered to take care of the proceedings as when they are going on. Thanks for listening to the separation and the divorce part under the Hindu Marriage Act. You can download this presentation from www.jurisknowledge.com. Thank you.